Hello, everyone, and welcome to the Navigating State Responses to Genocide panel of the New Lines Conference on Gender and Genocide in the 21st Century. I am delighted to introduce the moderator, Naomi Kigler, and the panelists, Adam Keith, Dr. Melanie O'Brien, and Professor John Packer. This should be a really great conversation. So without further ado, Naomi, I'm going to hand it off to you.
Emily, thank you so much. It's an honor to be able to join all of you today with this phenomenal panel. It's a really timely convening focused on centering a gendered perspective into genocide and atrocity prevention. And this is an issue that features regularly in the work that all of us are doing. And it's critical that we see these seemingly parallel agendas be intertwined as they should be. The absence of that reality has meant that gaps exist within the atrocity prevention community's understanding of the early warning signs of risks, primarily to women and girls. This is often seen in risk analysis that refer to looking for specific risks to vulnerable communities with little guidance on what to look out for. And you'll see that if you take a look at the UN Framework for Analysis on Atrocity Prevention, the USAID risk analysis. Similarly, there's a gap in the policy tools to help mitigate the risks or provide protection when crimes occur. This also contributes, as previous panels have explored, to the use of improper interview and documentation efforts, often undertaken with well-intentioned purposes, but not in compliance with international standards, and sadly, all too often, a fetishization of crimes, especially against women and girls by the media. I and many of you have had the distressing experience of going to meet survivors. For example, in my case, in an Iraqi IDP camp where I met a young man who said to me, "You must be here to interview my sister, the rape survivor." In talking to the camp manager, it appeared that in violation of camp rules, journalists were daily entering the camp to seek out experiences of sexual violence in a potentially re-traumatizing way. One area that has received considerable attention in recent years has been on having governments make formal genocide determinations. Here too, there's rightfully a need to integrate a gendered lens. As has been discussed earlier, perpetrators have long targeted the regenerative capacity of communities, but for a host of reasons, including social taboos, that has not always received the due policy attention required. That is changing, and it poses real challenges when it comes to documentation and making determinations. To understand that, we need to take a step back and essentially address the state of play as it pertains to both genocide determinations, but also more broadly, governmental efforts to prevent these crimes from occurring in the first place. What was a decade ago a rare ask from civil society, including survivor groups, has now become a central focus of advocacy efforts. Our panelists will discuss government efforts, including the ad hoc nature of determination processes, some of the challenges, including proving intent, access to information, rule of law considerations, and the underlying dynamic that governments should be looking for and acting on risks, not waiting for a determination to cross or raise kind of a prosecutorial standard for prosecution to compel action. And understandably, when crimes occur, communities and others seek to have a determination, including to help set the historical narrative of what happened and to counter denial. We even think currently about the plight of the Rohingya community, where a very thorough documentation process was taken by the Department of State in the US context. I recall a conversation with a young Rohingya man in a Cox's Bazar camp where he said, "We're genocide survivors, but the world doesn't see us that way because the most powerful country in the world hasn't said genocide." Part of our role with this panel is to try to provide a bit more nuance on the process, help to manage expectations, include crucially that courts and governments may not, in most cases, make a finding of genocide, but that doesn't mean that the crimes did not occur. It speaks more to the legal and political realities and the challenges that exist. And such a finding should not be a determining requirement for preventive and protection actions. As a result, the panel is also going to explore what more states can do in responding to the risks and crimes. I'm really honored to be able to introduce our incredible panelists. Each are going to provide short remarks in which we'll then follow up with questions from the audience. Please put them into the chat box. The first speaker is Adam Keith. He's going to be sharing the perspective from the United States. Adam Keith served as a senior policy advisor for the Office of Global Criminal Justice at the US Department of State from 2014 to 2017, and as a director on the National Security Council from 2013 to 2014, developing, coordinating, and implementing policy on international justice, human rights, and on atrocity prevention. He held other positions as well within the Department of State, notably on Africa and Near East bureaus from 2007 to 2013. He is also the co-author of a report that we put out at the Holocaust Museum entitled By Any Other Name that explores the process of making genocide determinations and issues related to that. I'll share that great report in the chat box. John Packer is going to explore the Canadian efforts as well as broader prevention efforts by the UN and others. John is the Neuberger Jessen Professor of International Conflict Resolution in the Faculty of Law and Director of the Human Rights Research and Education Center at the University of Ottawa in Canada. Through his professional career, including 20 years as a staff member for IGOs, he has investigated serious human rights violations in many situations, including with the alleged genocide, notably in Iraq and Myanmar, and he still works on situations regarding the risk of genocide. He's become particularly active in calling for action in regard to the Rohingya and Uyghur genocides and other situations which feature widespread and systematic sexual violence, and has supported the integration of a gender analysis into these conflict situations. Melanie O'Brien is going to focus on Australian efforts, including notably how legislatures have been stepping in to fill policy gaps or compel policy action, notably in regards to the use of sanctions in the case of the Uyghurs. Melanie is an associate professor in international law at the University of Western Australia. She's an award-winning teacher of international humanitarian law, public international law, and legal research. Her research examines the connection between human rights and the genocide process and sexual and gender-based crimes against women and atrocities. She's also the president of the International Association of Genocide Scholars, and her work is focused on forced marriage and human trafficking, and that has been cited by the International Criminal Court in the Ongoing defense. She's also been an expert panelist on genocide prevention for the UN Office of the High Commissioner for Human Rights. It is my honor to turn it over right now to remarks from Adam. Thank you.
Thanks, Naomi, and thanks to the New Lines Institute for putting on this conference and for the invitation to speak. As Naomi mentioned, I'm here because I researched and co-wrote for the Holocaust Museum a report in 2019 with a former colleague on the US government's practice in making or not making statements that genocide has happened, genocide determinations. And I hope this is useful fodder for the conference and the broader discussion. Many of Todd Buchwald, my co-author, and I, and many of our colleagues were involved in or informed by some of the episodes that we talk about in the report where the US government was considering whether to state that a given crisis that crimes in a given crisis constituted genocide. The shame of the US government's avoidance of the term genocide in the Rwanda context definitely loomed large. But also the frustration, the bureaucratic frustration of trying to secure a genocide determination in the context of ISIS crimes against the Yazidi and other minorities, as well as, I think more subtly, the disappointment that activists felt, some activists at least, in the aftermath of the 2004 genocide determination about Darfur. The disappointment about the impact that had on US policy and on the ground. And I think our core take is that obviously preventing or stopping a crime is more important than naming it, but that mobilizing preventive or responsive action is hard. And that there is some indication, at least in some circumstances, that securing a genocide determination from a potentially authoritative voice like the US government can help in that regard. And that in any case, regardless of the instrumental value of a statement like that, there may be intrinsic value to the victims, to the historical record. So the recommendations that we've made in our report are both sympathetic to the concept, to the advocates who seek these kind of statements, but also somewhat skeptical or cautionary to the extent that it's important that this not be the only mobilizing tool in the toolkit, given its many shortcomings, and that not every mass atrocity meets the admittedly arbitrary criteria of the Genocide Convention, given the doubts about the US government's credibility in some cases when it makes these statements, and given the risk that future crises that may not fit or may not seem to fit the Genocide Convention's criteria risk also being seen as not rating preventive or responsive action. So what I'll cover is our findings about what the US government process has been about in making genocide determinations when it has actually happened, what has been the impact, and our recommendations, again, just very, very top lines. So We wrote the report and did the research before some of the focus crises, but I think the findings on the process remains the same, which is, as Naomi alluded to, this is essentially an ad hoc process. There's no formal policy or law requiring or establishing the process for a US government genocide determination. It's entirely discretionary whether to conduct the process. Especially in the 1990s, this practice became much more formalized. I think we can say it's bureaucratically rigorous. It involves relevant components and experts from within the State Department, regional experts, legal experts, intelligence experts. It involves analyzing the facts, and in some cases, collecting additional facts, and then reviewing them against the law, inevitably also reviewing the policy implications of making a genocide statement, and then ending in a top-level decision, usually by the Secretary of State. The process relies on the Genocide Convention definition and therefore suffers from its high hurdles in terms of evidentiary requirement to show specific intent to destroy a group, and the convention's lacunas as well, not covering political groups and case law that has interpreted it to require physical destruction and not just cultural or the destruction of the identity of the group. The process can be slow, from a few weeks to 16 months to ultimately never happening. When a factual issue is the cause of the delay, it's usually the question of showing eliminationist intent. It's always difficult to make the inferences necessary to do that, and presumably more so for subtler crimes that don't entail mass graves and mass slaughter. And in that sense, I hope that there will be more reporting about the internal process that led up to some of the more recent genocide determinations. The US government has made statements about other types of atrocity crimes, including crimes against humanity and war crimes, but much less often. I'm happy to talk about that if that's of interest. I think it's important to focus on when this happens. If the process for considering a genocide determination has become more formal, the initiation of the process is not. Again, it's entirely ad hoc. And I would stress that it's not spurred solely by the apparent gravity of the crimes that are happening. In our report, we pointed to some null cases, as it were, where potential advocates, confronted with a mass atrocity situation, decided that for various reasons it wasn't worth the bureaucratic effort to pursue a genocide determination, and that highlights the fact that whether or not this happens. Whether or not the consideration is given to a determination depends on prompting by internal or outside advocates who are weighing the costs and benefits. And some of the factors that we found, some of the factors that we found accounted for advocates deciding to pursue, and thus for the US government sometimes ultimately proceeding to make a genocide determination, included whether there was a favorable perception of the victims and a negative perception of the perpetrators in a broader context, clear imbalance in culpability between the parties to a conflict, widespread attention in public media coverage or congressional interest, a gap between actual US activity in response to a situation, what expectations for that activity might be, the likelihood of actually being able to show that the Genocide Convention criteria are met, and also, as I mentioned, just the anticipated impact of obtaining or pursuing a determination being worth the anticipated effort. With those criteria in mind, there's no reason per se that genocidal acts other than mass slaughter couldn't satisfy or trigger those criteria. I think in practice, it's easy to anticipate that, again, high body counts, mass graves are more likely to do so than subtler crimes like forced sterilization or transfer of children or sexual violence. And then on the other side of the coin, we also tried to bring out the factors behind the US government's reluctance to consider or resistance to making genocide determinations, which turn primarily on the anticipated political pressure to take specific actions or to take a greater degree of responsibility in dealing with a situation that the US government expects would flow from its own a statement that genocide is occurring. And I would stress that these are not just expectations of the use of military force, but much more generally limiting the US government's flexibility in how it handles relationships with the perpetrators, or just or in any way, actions that would be inconsistent with current US policy. We focused also on the impact of genocide determinations, which is we found very hard to isolate. So we talk about expectations and reality to the extent that we can distinguish. what might you get from a genocide determination based on the record. And again, I would start by stressing the possibility of intrinsic values, the importance of bearing witness to the gravity and nature of a crime, the importance of setting an accurate historical record and showing empathy for the victims and the specific, the nature of the abuses that they're facing. It is hard to quantify the value of those benefits of making a genocide determination, but we consider them to be real and important to keep in the discussion. What advocates often focus on are the instrumental effect of a genocide determination, which can range from, I think we try to challenge the idea that there's much to be expected in terms of legal impact. Of the US government view is that there are no particular legal consequences to making a genocide determination. Happy to discuss the difference between the US government view and the ICJ and other views about what the obligation to prevent and punish genocide does and doesn't entail. But generally speaking, this is not the source of reluctance for the US government. The issue, as I mentioned, turns more on the moral and political expectation of action. Again, happy to talk in more detail about some of the cases that we point to. Again, Darfur, I think, is an interesting case in that it both shows the potential and the limits of the tool, as it were. The 2004 Darfur genocide determination was done in part with a view to mobilizing other governments. In practice, one of the consequences of it that I think you can draw a fairly straight line to is that having put itself out there dramatically in calling almost standing alone, calling what's happening in Darfur a genocide, the US created pressure on itself to allow the referral of the situation to the International Criminal Court, which otherwise I think never would have been the case. But again, there's the fact of disappointment. Secretary Powell said, no new action would flow from this announcement. It didn't prove persuasive to others. There was a lot of skepticism of the merits of the finding, given the US bad relations with the Sudanese government. And we saw a number of the activists that we spoke with that as a result of this sort of felt disappointment in the impact of the determination, that some activists reoriented their focus away from pursuing genocide determinations in future crises. I think I'm out of time, so I'll switch to the conclusions and recommendations. I would stress that genocide determinations are not in any meaningful way about early warning or upstream prevention. By the time a determination is being considered, any legal obligations are already triggered. Commitments to never again kind of commitments are already engaged and in question. So again, just to stress that this is not a substitute for action. That doesn't necessarily mean it's not worth pursuing. Again, because of the intrinsic value and the possibility of instrumental value, we didn't recommend ending this practice as other governments have done or said that they have done. We do focus a little bit on how to make the process work better. It's hard. I think the rigor of the process and the delays that flow from the genocide determination review process emerged partly for defensive reasons, to guard the government against pressure that would flow from using the term. But the rigor also turns out to be important to the credibility of these statements, and the credibility in term is necessary for them to have an impact, a political impact, and I think to be sustainable over time. So we have some suggestions at the margins about how, yes, these decisions should still be made at high levels. It's reasonable to continue using the Genocide Convention as the standard, but leaders need to weigh in to resolve bureaucratic disputes that play out over a period of months. I think the most important point for today's purpose, though, is that this can't be the only mobilizing tool in the toolkit. We have some recommendations about how it's important to show that genocide, in terms of the Genocide Convention, is not the only mass atrocity crime that's worthy of a policy response prevention effort. That's easier said than done. One thing that we point to is that the US could adopt crimes against humanity legislation, support a crimes against humanity convention. The point more generally is to be candid and clear about what the rationale for what the government is saying or not saying. If you can say that it's genocide, explain why, make a convincing case about the intent to destroy. If you can't or won't say it, explain why the crimes are nonetheless grave and what the government is doing about it. And last, it's important for the US, for governments to support other voices too, to the extent there are benefits from genocide determinations. They don't have to come from government statements. Commissions of inquiry and other credible bodies can make these statements. And a final cautionary point is that we just encourage advocates to be realistic about the possible payoff of pursuing a genocide determination as they set their advocacy strategy. So I hope that's helpful. I'm happy to discuss further.
Thanks so much, Adam, for that remarkable tour de force in describing in detail how the US government has been approaching this, but also with some lessons for civil society in that regard. I just wanted to kind of reiterate a few quick points there as we go into the next discussion from John. As you said, in the US context, and I think this will become an interesting contrast with both the Canadian and Australian, the process has become more formal and, as you said, is quite rigorous in terms of consideration of the law, but the initiation of that process has not. And notably from the perspective, again, of this kind of gendered analysis, we're not necessarily looking at the gravity of the crimes as a triggering element. But as you also said, high body count, though, does often more likely trigger and genocide determination analysis, more so than things like forced sterilization, transfer of children, issues that, especially in the context of the Uyghurs more recently, we have been grappling with. Also, just reiterating a point that you made, that from the US perspective, there are no legal consequences of making a genocide determination, which I think in many cases people are not necessarily aware of. So we might want to just in the Q&A go back to that particular point. And as you said, the decision to make a determination after the weeks, months, and in some cases years of consideration is often based on moral and political expectations. And finally, just as we think again about the Canadian and Australian context, as you notably said, these determinations are often just made through a statement by the Secretary of State without any real description of kind of what was the legal analysis or the factual information that helped to lend to a certain finding. That makes it hard for other governments who maybe don't have access to the same information to make similar findings or undertake a similar rigorous process due to limitations that they have in terms of access to intel, presence on the ground. So there is a pretty stark difference in terms of what the US government is capable of doing in terms of formal determinations, and perhaps other governments as well. And perhaps if that information was made public, it would lend itself more to more easier considerations of these issues by even Five Eyes governments, more broader groups, to create a real kind of coalition of concerted preventive and protective action. I'm going to turn it over to John to hear your reflections on the Canadian approach and then broader prevention efforts.
Thank you, Naomi, and thanks to New Lines Institute, and in particular to Emily for this initiative, which I think is overdue and badly needed to bring this gender perspective. Thanks also for the prior sessions, which I found really excellent the last day and a half. Let me just emphasize, I'm very glad that this session in particular emphasizes the state responses, and I would say state responsibility for those who don't follow perhaps international relations, international law that closely. The state is the primary actor in international relations. It is the primary, holds a primary responsibility in international law. And very frankly, as we just saw in Afghanistan, in the absence of the state and the state's enormous resources and capacities, it's very difficult to do much in these kind of matters absent the state. So the state is crucial, and we really have to understand what this implies if we're speaking about genocide. Let me say that it's also in the contemporary period more visible now that we can see the kinds of, Adam mentioned, subtle or less subtle actions which result in egregious conduct in violation of the Genocide Convention, or for individuals in violation of the Rome Statute, or other international obligations that are related to it. Let me also say that we can see increasingly the risks in real time. In Afghanistan, for example, you don't have to be a brain surgeon or a rocket scientist to connect the dots between the Hazara, for example, as a protected group, and the risks for Hazara women and girls in particular in that circumstance. So we can see. Let me also quickly thank a few of the previous speakers. Grant this morning pointed out that in the absence of a gendered analysis, there is in fact a gendered prejudice, which we have to be conscious of. And in particular, Grant correctly pointed out that in a risk assessment, which should be done, and whether you call that a determination or not, there's a risk assessment, which is a duty of all states under the Genocide Convention that follows from the duty to prevent. One must be conscious and observing and essentially constantly assessing risks here. And obviously disaggregating information and effects would be pertinent to that, especially if we understand where the burdens fall in terms of certain conduct, more or less on women and men. And we heard some of that already. We find that though, if it may be that men feature more in the areas of killing or immediately in the conduct, for example, where there's a nexus with armed conflict, that's less subtle, again, to use that term, doesn't mean less a violation. And in fact, it may be from a risk analysis and prevention perspective, precisely in the more common conduct affecting women with regard to, for example, effects on births and so forth. So being conscious of this, I think, is rudimentary. Let me also say that I agree entirely with Sarah and Aaron and the points about, the preoccupation and the hierarchy that is implied of acts here, which of course does not exist in the convention. It's not a matter of the law, nor from a victim's perspective makes any sense whatsoever. To say that if one is subjected to, for example, an act of rape or sexual violence that has a genocidal intent, that somehow it is less or does not compare with other acts is no solace to the victim. It's patently inappropriate, and I would say detached from the way in which human conduct occurs. So to the question put to me about the Canada, and I don't speak for Canada or the government of Canada. In fact, I've lived half my life and most of my professional life outside of Canada. Canada as a state is a state party to the Genocide Convention, and actually to most, it has been relatively good at being a party to most of the kind of human rights and international law and criminal law instruments, but our actual conduct is utterly inconsistent, or consistently utterly difficult to understand. The gap is between rhetoric and conduct. So for example, Canada had not only a consensus, unanimous adoption of resolutions of both houses of our parliament acknowledging genocide of the Rohingya, including under the Westminster model. That meant that members of government, our prime minister, our foreign minister, plenipotentiaries of the state voted in favor. So they bound the state, despite their effort to invoke the non-binding character of the resolution. And yet, when it came to the Uyghur situation, Parliament voted unanimously of those who were in the House, 266 to 0, unanimous save for one, our foreign minister, who came into Parliament and did an extraordinary thing that's relatively unknown in parliamentary procedure, abstained on behalf of the government. We don't know what that actually means, but clearly made a statement that they didn't want to say anything that would be binding in the light probably of the Rohingya situation. And yet at the same time, essentially in the last couple of years, we've had commissions of inquiry in Canada on missing and murdered Indigenous women and girls, and on Truth and Reconciliation Commission, both of which concluded elements of genocide. And the Truth and Reconciliation Commission concluded that there was what they call cultural genocide, but if you read the reports, the elements of genocide, the acts and intent appear evident. And in the missing and murdered Indigenous women and girls case, our prime minister, they not only did conclude, the commission, that there was genocide, but our prime minister readily and immediately accepted that. Now, if you're just comparing the case of up to 1,600 missing and murdered Indigenous women and girls over some decades in the context where some of those murders are committed even by Indigenous men, and then you compare that with the Uyghur situation, you might scratch your head and say, how can our prime minister conclude that there's genocide in the Canadian context, and he has no idea and won't draw a conclusion in the context of the Uyghurs? I mean, the only answer to that is politics. That's not law, it's politics. And let me say, in the case of Canada, we are near in a number of other situations. Canada is a major donor, for example, and on the ground with embassies in the Republic of South Sudan, in Cameroon, where there are absolutely risks or actual conduct that amounts to or is teetering on genocide. Canada has declined, notwithstanding these declarations, for example, the Rohingya, declined to join the International Court of Justice case, despite the call of the Vice President of Gambia at the General Assembly 2 years ago, calling upon all member states to join that case. What Canada has done is very subtle, to use that word again, with the Netherlands, to issue a single sheet of paper saying that they are intent on intervening, which is an opaque reference essentially to Article 63, which is say not to join the case, but to comment on the construction of the convention. And they may do so, there is rumors they may do so with regard to sexual violence or gender. We don't know, but that when that will be, I mean, it certainly hasn't been now, and it's not going to be for some time. And what it'll amount to, God knows. Otherwise, Canada has supported, for example, the establishment of the IIIM in the case of Myanmar. But of course, we also have no idea when any cases would emerge from that and what consequences that would have, while 1 million refugees languish in Cox's Bazar, or 450 to 600,000 Rohingya are at utter risk inside the country. So in short, the Canadian experience here is a gap between rhetoric and conduct. And in the midst of all of that, the slow movement, there is business as usual. And that's really the sum here, if you actually examine conduct. So what is Canada's obligation? I want to emphasize this because I was struck by Mr. Keith's reference to no legal consequences in the US. The international law legal consequences is that if a state knows or should know, and certainly if they have acknowledged and declared that there's genocide, there is a legal consequence in international law. And that legal consequence is to take steps in the duty to prevent, steps that would be heightened if there is proximity, heightened if there is degree of influence. What are the possibilities for action? In that regard, Canada is a G7 state, a wealthy state with enormous capacities that at a very minimum should include a political strategy, active engagement, mobilization, studies, and so forth. There's so much that could be done, and then we have to ask, why is so little in fact being done? And I think that underlines a kind of potentially performative element of Canada. And that's not to mention our declaration of a feminist foreign policy that actually has no policy. There is literally no policy attached to that. I'm going to conclude by simply referencing one important element that was brought up by Akila in the interview yesterday, and I want to thank her for this. We should draw the lesson from the Akayesu case that the treatment of sexual violence in that case and the conclusions important to jurisprudence likely would not have happened in the absence of Navi Pillay being on that tribunal, and there being, as Akila pointed out, some women lawyers involved in the case agitating. And in my experience here, I want to connect with the women, peace, and security agenda. Very frankly, in the absence of proactive engagement of bringing women into these processes, we are unlikely to see movement. And I think this is, despite the declarations of Prime Minister Trudeau, just elected yesterday again, I think that the gap that I've mentioned between rhetoric and conduct will persist until we see yet more engagement of women actively in these processes. Thank you very much.
John, thank you so much for that. And thank you for starting it also just with situating the reality that our current government, sorry, I should acknowledge I'm a Canadian, has explicitly stated that they are essentially governing a genocidal state, with the acknowledgement of the fact that from their perspective, not only was genocide committed in the past, but they've actually, as you noted, stated that there is an ongoing genocide against Indigenous peoples, notably Indigenous women, which raises a whole host of interesting questions, as you said, around what are the preventive obligations that the Canadian government has? What are the obligations of other governments in the international community under the convention to aid, assist, compel preventive actions to be taken? It also, from a political perspective, internationally raises really interesting questions. And we've already seen the Chinese government talk about Canada and the nexus with residential schools, Commission of Genocide, each time the Canadians raise concerns about the Uyghurs. So it is an interesting dichotomy there, because as you also mentioned, when it comes to genocide determinations, be it for the Rohingya, Uyghurs, or others, those have been parliamentary actions. And as you said, the ruling party does weigh in, but contrast that to what Adam has said. There is no Office for Global Criminal Justice. There is no kind of legal process in a Canadian context. There's no one tasked with doing a legal analysis. There's no one tasked with gathering information to feed into a consideration. There was a parliamentary committee and a set of hearings put forward in the context of the Uyghur case to try to illuminate a bit more what has taken place. But as you note, it's really an ad hoc initiative and process. Similarly, the creation of preventive strategies in these international cases is also ad hoc. There is a focal point, as with the Australians and the US, for the responsibility to protect, but there's no correlating staff or office meant to support that particular position. So you do get efforts like funding geared towards supporting an international effort to document crimes against the Rohingya, but it's not fitting into a broader strategy to either advance a normative agenda around genocide and atrocity prevention, or, to your point, integrate that in with the women, peace, and security agenda, which, as you rightfully noted, the government itself says is at the heart of Canada's feminist foreign policy, which includes the feminist international assistance policy and defense policy. There's no clear articulation of what that means from a genocide prevention perspective. So there's some real gaps there that hopefully the next government will attempt to address, but absent probably legislative pushes and civil society engaging is unlikely to change very much. So with that, Melanie, given how critical kind of legislative endeavors have been in the Australian context, let's turn to you for a perspective from Australia. Thanks so much.
Thank you, Naomi, and thank you to the New Lines Institute for hosting this event. It's been really fantastic. I want to start by acknowledging that I'm speaking to you from Wajak Noongar Budja, and I pay my respects to elders past, present, and emerging, and acknowledge that land was never ceded. So I know that during this conference, we're talking about contemporary genocides, but to talk about the Australian response, I do want to contextualize it with a historical genocide first, the Armenian genocide. So the Armenian genocide happened over 100 years ago, and yet the Australian federal government still refuses to acknowledge that this was a genocide. It has been acknowledged by other governments at state level, but not at federal level. And for example, apparently one of the reasons behind this is related to politics with Turkey. So the day that Australians commemorate those who have fought and died in war is called Anzac Day, which is held in April. And one of the ways that many Australians commemorate Anzac Day is to travel to Gallipoli in Turkey to commemorate a particularly pertinent battle in World War I for Australia and New Zealand armed forces there. And apparently what the Turkish government has done is to say to Australia that if Australia recognises the Armenian genocide, then it will bar Australians from coming to Gallipoli to commemorate Anzac Day. So they're essentially using politics, but also playing on the very strong Anzac and military historical culture that we have in Australia as a means of ensuring that the Australian federal government doesn't recognise the Armenian genocide. So bearing that in mind, that's a context to think about how we might react to current genocides. And so let's have a look at some of the modern genocides. In the interest of time, I'm going to focus on the reaction to the Rohingya and the Uyghurs, but happy to talk about other situations that have been discussed here in the Q&A. So the main way that Australia responds to crises like genocide is to implement sanctions. And we have two sanctions regimes. One is the UN Security Council sanctions regime, and we also have an Australian autonomous sanctions regime. So we implement the Security Council sanctions through the Charter of the United Nations Act from 1945, and we implement our autonomous sanctions through our Autonomous Sanctions Act and our Autonomous Sanctions Regulations from 2011. And then that will be added to with any specific regulations or other rules that need to be implemented, which may include amendments to legislation such as the Customs Act or the Migration Act. So we mostly have sanctions related to UN Security Council sanctions, but we do have 4 situations in which we've implemented autonomous sanctions, including Myanmar, and also 4 sanctions which actually have both Security Council and autonomous sanctions. So with regards to genocidal situations, Australia currently has UN Security Council sanctions against South Sudan and Sudan, ISIL and Al-Qaeda together, and the autonomous sanctions against Myanmar. And interestingly, there are no sanctions in place under either of these regimes against Ethiopia or China. So just to have a look specifically at Myanmar and the Rohingya, Australia actually first imposed sanctions on Myanmar after the 1990 elections, but some of these were lifted in 2012 after the democratic reforms that were brought about at that time. However, we did maintain an arms embargo because of the ongoing conflicts, weapons proliferation and human rights abuses that continued in Myanmar. So then in October 2018, in direct response to the UN fact-finding mission on Myanmar's report that came out, new sanctions were actually imposed. So that was actually a really positive step, and they included sanctions related to the supply of arms, but also several different sanctions related to designated persons, freezer of assets, and also travel bans. So under these sanctions, there are specific persons who are actually listed as designated persons. And at the time they released the list, it only had 5 people on the list. They were, of course, members of the Tatmadaw. And in fact, that list has not been updated since then. So it remains limited to just those 5 leaders, which is obviously a significant issue because, as we've heard talked about tonight, there is a systematic campaign, particularly of rape against women, that is obviously involving more than just 5 people in the Tatmadaw. Another huge issue is that Australia continued its military relationship with the Tatmadaw until well into this year. This was highly problematic, and it was despite calls back in 2017 when the Rohingya crisis really kicked off. Calls from Amnesty International and prominent individuals for Australia to cease military cooperation with the Tatmadaw, specifically due to the Rohingya genocide. But the government at the time refused to cease the relationship, and they argued that this was cooperation with the Myanmar military, aiming to promote professionalism and adherence to international laws, ironically, and that it's important we maintain lines of communication with the Myanmar military to do this. And this was despite the fact that, for example, the UK, which is obviously a significant partner and ally of Australia, ended its military cooperation with Myanmar in September 2017. So in June 2018, the government issued a response to the Rohingya crisis, and it made reference to allegations of ethnic cleansing and genocide, but it did not call the atrocities genocide. And essentially, the document admitted that the government's principal response has been humanitarian aid, making donations to various groups such as the World Food Programme, and that has been their response to the genocide. In this document, there are only 2 passing references to sexual and gender-based violence. So it's really not even on the government's radar. Aside from these sanctions, Australia actually continues to resist pressure to impose further sanctions on the Tatmadaw even after the coup, and even after Australian academic Sean Turnell was abducted, and it has been in detention ever since the beginning of the coup. And so the government says that it's that our military is making overtures with the Tatmadaw to try and get Sean Turnell released, but no more sanctions. And essentially what Australia is doing, and our Foreign Minister Marise Payne has said that essentially sanctions would not advance our interests, and our interests are supporting an ASEAN-led solution. But as we know, ASEAN's response has been also quite weak with regards to the Rohingya genocide. So essentially, there isn't a lot of talk about genocide. However, and also representatives from the Department of Foreign Affairs and Trade and the Attorney General's Department have said that Australia recognises states, not government, and so they're refusing to actually engage with the issue of the Tatmadaw as a government, particularly even after the coup. So there's no deeper discussion about the atrocities being carried out, including the Rohingya genocide. And in fact, a recent report put out by a government committee actually said the overarching message heard by the committee was enormous community frustration regarding the government's slow, reactive and inadequate response to the situation in Myanmar. So it's quite interesting because the US, the UK, Canada and the EU have all imposed sanctions against military leaders and businesses with ties to the Tatmadaw, but regional states like Japan, India, South Korea and ASEAN states have not. So that's the situation with the Rohingya. With regards to the Uyghur in China, it's quite different. As I mentioned, there are no sanctions with regards to China, and Australia is having a bit of a trade stoush with China, and there's quite an undercurrent of anti-China sentiment in Australia. And so that would play into any reaction that we're having. So what is going on at the moment is there was a bill proposed last year by independent Senator Rex Patrick with a very long name called the Customs Amendment Banning Goods Produced by Uyghur Forced Labour Bill. And that was assessed by a committee which said, this is a really important bill and we wholly support it, but actually what we suggest is that you make it more comprehensive. So Senator Patrick did that, and this year he actually reintroduced it and it was renamed the Customs Amendment Banning Goods Produced by Forced Labour Bill. So the idea of this bill is that it's global in nature. It applies a penalty to the importation of any goods into Australia that have been produced by forced labour. So that bill in August, just last month, passed the Senate, and now it has to pass the House of Representatives to go into law. So in bringing back to the topic of this conference, in thinking about gender, I had a look at the discussion. So every bill has what's called a second reading, and the senators could present their thoughts on this bill. And I looked through all of the speeches at the second reading, and there were only 2 mentions of genocide and rape. Well, one mention of genocide. Senator Janet Rice, she made reference to cultural genocide being undertaken against the Uyghur people, and she also made mention of systematic rape. And another senator, Raf Chikone, made mention of rape as well. So they were the only 2 senators that did mention it. Obviously, the context was much broader. They were talking about, systematic human rights abuses against the Uyghur, but also more broadly in China. So it was at least discussed in the context of Uyghur discrimination, oppression, and human rights violations, but generally the word genocide wasn't really used. So what I found so far is that Australia's response to genocide is, like John has said about Canada, more rhetoric than actual policy. And this is due to political considerations. It's due to lack of mainstream media engaging with overseas events, and so a lack of public pressure, similar to what Adam was talking about in the US. But also with regards to Australia, it's about geographical isolation. And I think it's also, and I can talk about it in the Q&A connected to our harsh refugee policies as well. But it's really interesting because Australia is a party to the Genocide Convention since 1949. It supports principles and initiatives like R2P, contributes financially to humanitarian aid crises. It contributes members to, for example, the Theodore Committee. It has a national action plan on violence against women and girls. It's contributed money to the ECCC, for example. It's a state party to the Rome Statute of the International Criminal Court. But essentially, it's really, again, ends up being a lot of rhetoric without real action in practice. And particularly with regards to the details of genocide, including the gendered elements of these genocides that we see.
Melanie, thank you so much for that. I think it's incredibly stark, as you said, the contrast between the rhetorical commitments. I mean, when we think of the role that Australia's played, including when they were on the Security Council in advancing the agenda around protection of civilians, but also for the last, decade plus on the responsibility to protect, it hasn't actually translated, similar to Canada, into, this is a bit of a wonky kind of turn of phrase, but the institutionalization of atrocity prevention. And both Canada and Australia have really been at the fore of defining what the women, peace, and security agenda should look like internationally. But it's pretty humbling to hear about, again, the gap in terms of actually domesticating that and having that form kind of policy. And then, of course, the important role that legislatures play in not just a source of accountability and a check and balance on whether or not governments are living up to their obligations, but actually in taking some of the preventive measures themselves or trying to enact them, as you mentioned with the creation of the Forced Labor Act. I am struck as you were talking just around the statements on in regards to the Rohingya. I just did a quick look at the various Department of State statements in that context as well. And similarly, there isn't a reference to crimes of sexual violence and others, which is rather stark given what actually occurred. I want to remind everyone that they have the opportunity to put questions into the chat function for our fantastic panelists. And I thought maybe I would pick up just, Melanie, with you on that last kind of point around what type of preventive efforts you think that the Australian government could or should enact in regards to atrocity prevention, but also to address the gap that you've noted when it comes to looking at a more kind of gendered approach. Thank you.
Well, how long have we got? I think to start with, being a more active player with regards to thinking about atrocities, particularly in our region, would be really important. And I think that rather than just consistently saying, oh, we're going to let ASEAN handle it, Australia does need to show leadership in the region. And I think our geographical isolation leads to a bit of complacency in that regard, because we don't have land borders with anyone. We're not threatened, so to speak, with a mass migration of refugees coming in. And so it's easy for the government to just kind of stand back and do nothing rather than take leadership in terms of atrocity prevention. And I think this has also led to a second suggestion, which is actually our refugee policy. So I know we're talking about genocide and genocide prevention, but I think this is directly connected. And I'm sure everyone is very aware by now of Australia's horrific offshore detention policy, and that we detain refugees in offshore detention indefinitely if they've come by boat. And it's particularly relevant because some of those refugees were Rohingya, and they ended up being settled elsewhere. They ended up being settled in the United States and in Canada. And I think it's really interesting to make the connection, because it then politically, and I mean domestically politically, wouldn't be helpful for the Australian government to talk about the Rohingya genocide and to declare it a genocide, knowing that we are holding Rohingya refugees in indefinite detention for years in offshore detention. So the government is extremely conservative, and they're sticking to this refugee policy for anyone coming by boats, and they particularly wouldn't want to be recognizing the Rohingya genocide because they would have a fear. The whole goal of offshore detention is a deterrent for refugees to flee here by boat. And of course, that might be something that the Rohingya would do, thinking about where they are geographically located. They're more open to talking about the situation with the Uyghurs, which they're quite public about, as I said, with this bill. And they also held a Senate committee hearing where they heard testimony from a lot of people, including victims. And they're more open to that because of the anti-China sentiment that is going on at the moment. And because in the past, when Tiananmen Square massacre happened, we actually brought in a lot of Chinese refugees following that. So we have a relationship with Chinese people, even if the relationship with the Chinese government is relatively strained at the moment. So I think, and I know that seems broad, but I think our refugee policy is problematic. I also think that, and I want to bring it again back to gender specifically, one of the issues with our government is that it's extremely male. And this is has been of huge discussion domestically over the past few years, because the majority of ministers are men and the majority of MPs are men in our government, which is the Liberal National Party coalition. And this may sound confusing to people who aren't familiar with Australian politics, but our Liberal Party, which is Liberal with a big L, is actually conservative. It's not Liberal with a little l. And so they're predominantly male. And so their interest in issues around women, particularly violence against women, is incredibly low. And we've seen that at a domestic level in the past year, when there has been a lot going on here in relation to, for example, a female staffer was raped in the Foreign Minister's office, allegedly, and a lot going on around that. So if you think about that at a domestic level, there's an inability to deal with violence against women. There's no way that this government is going to look outside our borders and be concerned about violence against women in a genocidal context in a geographically remote location. So in terms of what can we do better, we can have a government that, and similar to what John was talking about, with more women in it to draw more attention to this and actually implement more of the action through our national action plans on violence against women, but thinking about them more broadly and further beyond our local region, just in the Pacific, which is sort of where we've really been focused, and not going anywhere beyond that.
Thanks for that, Melanie. John, turning to you for your perspective, and maybe if you don't mind too, you did allude to Canada's feminist foreign policy and the priority on kind of women, peace and security. Just for those who aren't familiar, do you mind just articulating what that in theory means and then perhaps in practice?
Well, of course, you might recall that, viewers might recall that when Justin Trudeau came to power, he declared, among other things, that he was feminist, and he was lauded and toasted internationally for that. And this idea of a feminist foreign policy, which came after Canada adopted a feminist international assistance policy, a FIAP as it's called here, which within its development assistance context brought in a feminist perspective. It actually just does prescribe a number of things. It is a detailed policy and accompanied with some money, not new money. I want to underline, it wasn't a new cash infusion, but it was a collection of $30 million a year for the first 5 years. I'm not sure what the current funding is. That's for the whole world. And Canada gives billions of dollars in aid. So it's a pretty kind of modest, but nonetheless, it was significant and symbolic. The feminist foreign policy picked up on the tails of really the work of Margot Wallström as the foreign minister of Sweden. And Sweden really did adopt and elaborate, and you can read, a detailed policy and also named an ambassador. Canada did name an ambassador, not for feminist foreign policy, but for women, peace and security, Ambassador Jackie O'Neill, very competent and dedicated person coming from civil society. But the feminist foreign policy as such has not been elaborated. In fact, it's been ongoing a 2-year so far process of consultation of what it would be. So it's a little bit odd that there's a policy declared in the absence of an actual policy. Normally you would think you'd have white papers, you'd have discussions and then declare the final policy, which really begs the question of performative versus actual conduct. I want to stress that I'm in favor of a feminist foreign policy. I think, bringing in, if it would include specifically what we're talking about, a gender perspective, a gendered analysis. What's often lacking here is a gendered analysis of concrete policy and implications, as should be across the board, in my view. And for example, would include equity, diversity, inclusion elements, many different elements. So I think what we have to think about is what would this mean concretely in consequences. For example, Canada has created a really pioneering thing called the Canadian Ombudsperson for Responsible Enterprise. It's an ombudsperson, a woman, in fact, who is responsible to look at private enterprise operating anywhere in the world, which may be involved, implicit or facilitative through its supply chains and subsidiaries in abuses of human rights, to use the language of guiding principles on business and human rights. Now, if that would be infused with a gender perspective, which in principle it should be, if it had a feminist foreign policy, this should not only be monitored, but would also start to give us ideas concretely and signals, including of atrocity prevention, where those abuses, such as regarding the Uyghurs in Xinjiang, might be systematic on scale and with requisite intent. And so, I think these dots need to be put together and then elaborated in concrete terms of determined policy. And I believe that follows from the international obligations. There just hasn't been that kind of mobilization, and I think maybe there hasn't been the demand. And I'll add to that, if you allow me, one thing, because Canada does do, Melanie mentioned, we have Magnitsky sanctions. Yes, we have huge humanitarian assistance for the Rohingya, for example, almost 600 million Canadian dollars, which is giant in Canadian terms for a specific community at risk. But I categorize that as allowing business as usual to continue, and it's a little bit about bad appelism. If we can just identify those bad guys we might try someday, somewhere, God knows when, God knows how, then we can continue. And I think, again, I want to bring us back to the topic of the session, the responsibility of the state. If Canada would look more concretely about investments in Myanmar, trade relationships, I think that's where the rubber would hit the road and be meaningful.
Thanks so much for that, John. Adam, I was struck, both Melanie and John have been talking about deficits that exist in their government's approaches. Their governments, and in terms of when we think about the infrastructure, are considerably smaller when it comes to the bureaucracy that exists, especially in kind of Ministry of Foreign Affairs. And there are not dedicated offices that have a focus on, for example, international criminal justice. And you worked within an Office of Criminal Justice at the Department of State. Just wondering, you've had to interact with a number of different countries. When we think about recommendations for governments to think about how they can institutionalize atrocity prevention, how they can approach in a more systematic way considerations around the integration of a gendered analysis into crisis situations and policy responses, and this question around genocide determinations, how critical, I know we could open this up to a full day symposium on this topic, but how important would you say an office like yours is when we think about, encouraging the Canadian government, Australians and others to potentially establish an entity like that?
That's a really good question, and I think it could be very helpful. I mean, it's a question of inputs, right? Like bureaucratic inputs. I think other things being equal, it has been very beneficial for U.S. policy to have an office that is charged with, remaining aware of and in touch with developments in international justice, war crimes tribunals. In particular, I think is a parallel question would be about the Atrocities Prevention Board or its successor interagency mechanisms that exist, that have an early warning mandate to review intelligence on an interagency basis. So it's not just one analyst laboring away, maybe as a third or fourth item on his or her priority list, to force discussion of these issues and to shine a spotlight on countries that are not getting attention or thematic topics that are being neglected. I think that is all very helpful, and so sure, I would recommend it to other governments. And for example, Human Rights Watch made a big push a couple of years ago for the EU to create a special representative on international criminal law, to complement the focus of the special representative that they have, more narrowly focused on human rights. I think all of these are good initiatives and would be helpful. I think it's still just about inputs, and then the question of what actually catalyzes those inputs to produce actions that wouldn't have happened otherwise. And there, I think the challenge is rarely about a lack of early warning. I mean, one of the challenges that we faced and did okay on in the Atrocity Prevention Board context was taking a fairly warnings that ranged from somewhat clear to clear about the risks of atrocities emerging in a given country, not framed in terms of particular crimes. Is it genocide? Will it be war crimes? Will it be crimes against humanity? Just focused on the risk of atrocities, and turning that into actual spending on programs that wouldn't have happened otherwise, or a shift in diplomatic posture and messaging that wouldn't have happened otherwise. I think, to me, that's the real challenge that is hard to prescribe recommendations against. I think any government stands a better chance of doing well on that question if it has the sort of internal advocate, the internal agitator to start these conversations, to bring countries or issues to the attention of their superiors. The U.S. bureaucratic model is in some ways a sort of adversarial one, where you have the regional bureau is there to defend the sort of broad bilateral relationship as an interest of the U.S. government. The Human Rights Bureau or the War Crimes Office is there to press the importance of those issues in the relationship, and I think that's all very helpful. But to me, the challenge is creating the mechanism for uptake. And I think a lot of that has to do with the signals that senior leadership sends or doesn't send in terms of what's a priority. So I always embrace and talk up the bureaucratic and sort of structural recommendations, but with the caveat that they're about inputs. They're maybe necessary and definitely not sufficient to improve actual outcomes and practices.
I very much appreciate, especially that last point, necessary but not sufficient. And I think we see the example, as Melanie and John have alluded to what happens when you don't actually even have the bureaucratic apparatus just as a starting point. You have a much lower bar and greater impediments to overcome to actually mobilize action. I think that lends itself well to this question from David Hughes. It's a question about persuasiveness. Are moral or international legal arguments more effective when attempting to compel state responses to instances of genocide? Adam, that's an issue that you delved into in your report. Why don't we start with your thoughts on that? And please, for others, put your questions into the chat function. Thank you.
I'm sorry, the connection crackled at a key moment. Could you repeat? Is it the question that David has here in the chat?
Yeah. Yes, thank you.
I mean, I find it hard to answer. I mean, I think from the advocate's perspective, I think the right approach is to try everything. I think it becomes hard to tangle out or disentangle which, in the event of success, what accounts, what arguments account for success in mobilizing a response. I think my tendency is to downplay the legal argument. I take John's point. I mean, I think the U.S. government view about a state's obligations under the Genocide Convention to prevent is an idiosyncratic one. It doesn't find support in ICJ rulings. I don't think it's shared with by peer governments. As a practical matter, though, I think it is worth mentioning to advocates who are looking for effective ways to mobilize action that even success in showing that the relevant threshold for prevention obligation has been crossed is not, as a legal matter, going to compel action from the government that you're trying to mobilize. In practice, I think a combination of moral and legal arguments is most likely to be effective. I think we get into talk about genocide because we talk about this in the report. I mean, the language of genocide, I think, can supply a connection between a current situation in the world and the laudable commitments of the past. You said, U.S. government or other government, that you would never allow this to happen again. You said you would take actions to prevent and punish the crime. Well, here, because we have shown that the criteria, that the relevant criteria are satisfied here, we've shown that your past commitments are engaged here. By failing to do something in response, you're failing to live up to those commitments, as opposed to just more generally, failing to stop something that's happening in a very difficult world where bad things happen all the time. I think that's the appeal of. I think that's why advocates are so often drawn to the invocation of genocide language, because it provides a connection to these past commitments and can break through. I think some of the situations where the U.S. government's refusal to use genocide language has been most alarming or discrediting, are situations where it was keen to wash its hands of the situation. I mean, the period in April and May 1994, the initial U.S. posture was to walk away from Rwanda. It was to support and cause the withdrawal of peacekeeping elements on the ground. That became less tenable, and you can see this in the internal documents of the administration. That became less tenable. The greater it became clear that what was happening was a capital G genocide in the meaning of the Genocide Convention, because that's a kind of situation in which there are moral commitments, whether or not there are legal entailments that follow from that. So I don't know if that's responsive to the question. Like my sense is that it makes sense to use as many arguments as you can.
Thanks so much for that. And I think it speaks also to one of the kind of features of your report too, that at the end of the day, these are also political decisions. And there are political calculations that weighed in, so that even if you perhaps have been able to make a compelling legal argument, there are still other considerations that might prevail. And in instances where you can't make a legal argument, similar. Turning to Melanie and then John, and then there's a few more questions here in from the audience.
I think David's question is really important, and as I've talked about sanctions, it's a perfect segue, you know, to talk a bit more about sanctions. This idea of moral and legal. Technically, sanctions are a legal act, you know, particularly at domestic level, where a government has to implement those sanctions through legislation. But at the same time, they're a moral act, because what sanctions are doing is essentially creating an outcast of a particular state that is violating its obligations under international law. And, you know, sanctions can be implemented through, you know, as the UN does with acceptance, or they can be done in an autonomous way, which is, you know, partly what Australia does and other states do as well, including the United States. And it's really interesting to see what is the moral authority of these sanctions. So obviously the legal authority exists because, you know, we implement them. And so we say, yes, in this country, you know, we're freezing any assets that are related to these 5 members of the Tatmadaw, for example, or they can't travel through Australia or into Australia. So that's a legal implementation of it. But morally, how successful are they? And particularly if you're talking about, you know, countries like Myanmar or like China. China's very big. It's sort of like water off a duck's back. But when you think about Myanmar, which is traditionally a hermit state when it comes to international relations and international law, it doesn't really care. It's not a state party to very many treaties at all. It is a party to the Genocide Convention, as we know. But it's just not ever really engaged with international law and the international community through international legal regimes. And so therefore, to bring in sanctions against a state like that, again, in a different way from China, it's water off a duck's back, because morally they don't care anyway, because they are in their bubble that they exist in their country, and they have their power and they just continue to do what they do. So it's a really interesting question to think about, what is, you know, when you think about sanctions, whether they're actually effective or not, and you know, completely depends on actually the regime that you're putting the sanctions on, and whether it means something to them morally, because if it doesn't, then essentially they don't really care about the sanctions. So yeah, an interesting crossover with moral and legal influence there.
Great point. Thanks for that, Melanie. John.
Well, first of all, of course, this is a kind of classic question that comes up, you know, in a standard international law course. You know, how even in foreign policy circles, you know, is international law, is it politics, and so forth. To take the risk of commending people to read something, you know, Richard Falk, I think in 1963, wrote a lovely little book called Law, Morality, and Politics. And he was really riffing off of Hersch Lauterpacht's famous observations 10 years earlier that 90% of international law is politics. Now, of course, all law has politics and morality. There is no such thing as a law absent morality or politics. So this is a little bit of a false dichotomy. But to take the point, because we could imagine certain conduct which would be, for example, absent law. There's no law, but should we or should we not behave, you know, on the basis of a moral basis? What we're talking about here is where there is law. And so now the question is, there's a Genocide Convention. There's many other things here, really fundamentally linked to the UN Charter and so forth. Adam is, of course, right from a real politics perspective. If we're talking about what moves to action, then the question of persuasion, in David's question, persuasiveness, it probably follows from not only real interests, but also consistency of conduct, reliability, these kind of things, foreseeability. Even the basic treaty law notion, and the Genocide Convention is a treaty of pacta sunt servanda. That really just means a promise should be respected. Why? Why should it be respected? It's good that we can foresee each other. We can rely upon it, that our word means something. Now, all of that said, there is a distinction in law, that there are legal consequences of not complying with the legal obligations. So, for example, not complying with the Genocide Convention would give rise to not at least a state party, leaving aside Jus Cogens, but a state party could act in response to that, should act from a preventive perspective, including countermeasures which themselves might be otherwise unlawful, what's called a retortion. That's a legal consequence of a legal obligation, what can and should be done. So it's not just morality and it's not just politics. There is an importance here. And when we are talking about genocide, we are talking about a cornerstone of the entire post-war, Second World War, international rule of law. So I don't want to leave it as a kind of, it's all up there for us all to work out. No, there actually is hard law here, treaty law, specific obligations on the three states we're talking about, USA, Canada, and USA.
Thanks for that, John. And I think you've all kind of also articulated what the intersection is between making the moral arguments, the political case, and then the legal. And I think just, anecdotally from the perspective of those who advocate on these particular issues, one of the really unfortunate consequences of the approaches that our governments take is that often it's the experiences of individuals, their stories, they're having to share them and in many cases relive the trauma of the experiences that they've had, that often needs to be constantly invoked to try to compel action. You think of the example of the Uyghur community today, the Rohingya community, the Yazidi, and increasingly more often than not, it's the voices of women and young women who are being put at the fore, and often in really, perhaps I would say, ethically questionable ways as well. And I think it really begs all of us to think about what is it that, in the absence of really kind of an institutionalized process and making these types of considerations rote, what is the dynamic that we are creating in order to help strengthen the moral and legal and political case for action. We have a number of questions that I just found. I'm sorry, I did not realize there was a Q&A button. So I want to just note one of them says specifically, the US genocide determination process is quite limited and gives more attention to situations where mass killing takes place. What can be done to change this and make the US government, especially State Department lawyers, recognize this full spectrum, including of gendered genocidal violence? I'll broaden that out because I think it's pertinent to all governments, and it goes back to one of the points that I raised just at the opening, that though there has been historically a reliance by perpetrators on targeting like the regenerative capacity of communities, we're seeing that much more kind of brought to the fore and more publicly discussed. How should that be changing the considerations of lawyers? What are some of the challenges that exist in integrating that type of analysis into genocide determination processes, but also even just evaluation of the risk of these crimes being undertaken by governments? Is there anyone that wants to take a stab at that one?
Two quick things. One, I think it's important to have gender. I think Soretta said earlier, there should be standard gender training and brought in, and analysis applied broadly, and certainly with regard to atrocity, crimes and so forth, analyses. So that's something, but probably in my view, to have more women. I'm sorry to make this point again, it sounds simplistic, but from my own professional experience, 35 years professional experience, in the absence of having those affected or having a particular perspective. This would go for minorities and the reasons why we want inclusion and so forth, but women in particular, to bring this perspective. It's not going to happen without. So that's one thing that I would advocate. But I wonder if I may ask Adam, from what do you think was missing that could have done better? Because it would be good to have more foreign ministries, leaving aside the resource implications, more foreign ministries with kind of dedicated units. Canada, by the way, has a international crimes unit in our Ministry of Justice. If we had a more dedicated approach, what do you think would have strengthened this? I'd be interested to know from your professional experience.
Strengthen the genocide determination process, or?
Well, specifically enhancing a gendered analysis. Yeah.
So I guess a couple of points. I mean, to the original question, I think these governments and the U.S. governments typically don't make decisions in the abstract or change practices or set precedents in the abstract. So I think my primary suggestion would be that, in a case where gender to genocidal violence, as the questioner says, is being neglected, isn't featuring in the State Department's remarks about other atrocity crimes, or is being neglected as a whole. I think making the case in that specific context that a genocide determination is called for, or specific recognition of the nature of the crimes, the gendered nature of the crimes is called for, I think is the best way to set that precedent or change that practice. I think at the level of inputs, I would say, so I've been out of government for 4 years now, so I haven't been involved in the processes around the most recent set of cases where genocide determination happened or were considered and didn't happen. Bureaucratically speaking, in addition to the Office of War Crimes Issues, the Human Rights Office, there's an Office of Global Women's Issues that contains a number of colleagues and former colleagues and experts who I think take this perspective and whose participation in these processes would be invaluable for the kinds of reasons that John suggests. Again, ultimately, you still have the question of taking these inputs and turning them into different statements and different actions. And again, I think it's the leadership of the department and the leadership of the administration that determines whether that happens. I will also take the opportunity to say I should have been clearer in my remarks when I referred to some atrocity crimes being subtler than others. I meant that from the perspective of the analyst or the lawyer thousands of miles away from the crime, and the victim who is trying to make the case, the lawyer or the analyst who is trying to make the case that genocide is happening and is used to relying on overhead imagery of mass graves or something like that. I think previous administrations have tried to fill that gap or solve that, fill that lacuna in some cases by sending documentation teams in the Darfur context, the Sudan 2 areas, and the Rohingya case that are better able to hear more directly from the victims and not suffer from these biases. The bias, I think, toward again, like mass killing, mass grave kind of crimes that are visible from space or otherwise. And I wish I knew more about the mechanics of the findings of some of these processes, especially how the process played out between the submission of the Rohingya documentation team effort and of the decision or non-decision to say anything about the nature of the crimes. But I think that is an important tool to filling that kind of gap. The decision to affirmatively seek out information that goes beyond what the intelligence community or embassy reporting would normally supply.
Thanks so much for that, both John and Adam. It's interesting just in the context of the Uyghurs that this is a step that could be taken by the US government with the support of like-minded states to undergo, a bit of a more strengthened documentation effort of those who've been able to actually get out of China. It's obviously incredibly hard to access detention centers and other locations in Xinjiang, but there have been people coming out. There are a lot of efforts being taken primarily by Uyghur organizations to collect testimonies, but in the absence of an international fact-finding mission or commission of inquiry or an investigative mechanism under the rubrics of the UN, it hasn't been done in a systematic way. So there are some real deficits, unfortunately, in some of that information. And as you mentioned, Adam, there are ways to get around that and specifically ask the types of questions that the individual who posed the question around the gender perspective of the crimes is looking for. And I think there are certain types of crimes that necessitate that added focus and prioritization. I'm conscious that we only have about 5 minutes left, and we do have a number of questions that were posed. I might just actually turn to remarks from each of the panelists as we close. I do want to just mention there was a question specifically talking about the violence in the DRC and whether or not that could be considered as genocide under international law, given the use of mass rape. And there has been at times kind of ethnic undertones to the violence that's taken place there. That might be something panelists can also address afterwards if there's a way through New Lines to kind of respond. Similarly, just the frustration and dismay that despite evidence, there's a reluctance by certain governments to make findings of genocide against the Uyghurs or the Rohingya, which I know that many feel. There's also a question just regarding the context of genocide in mass killings. So just want to acknowledge some of the questions, and thank you, Melanie, for responding to the one question that was put in there regarding the new submarine deal for Australia, the US, and UK, and how that implements policy on China. Apologies that we didn't get to more of those questions. But if you don't mind, I'll just turn to each of you for some closing remarks and perhaps some thoughts on a way forward or ways that each of the countries that you've highlighted, if you haven't already, could strengthen their responses, or if you have any recommendations for also civil society on how they should think about, especially genocide determinations, that would be wonderful. Thank you. Melanie, why don't we start with you?
Yeah, I think going forward, speaking from an Australian perspective, there is a little bit of hope from us because what they're looking at the moment is creating a better sanctions regime that we have. So essentially a Magnitsky-Law sanctions regime, because that's not really what we have at the moment. It's quite limited and it's quite cumbersome to actually apply. So there is a significant, essentially a review underway at the moment into overhauling our sanctions regime and bringing in a much stronger and more flexible sanctions regime that we could implement. So I think that's a really good start. I'd also like to see a change of government in the next election, hopefully in the next 6 months, which would, bring some changes to that, to the government and the way it perceives refugees coming in from outside, but then also the way it engages in international situations, particularly those that are in our region. And I think I can say at the moment that something like Tigray is not even on the radar of Australia because it's too geographically removed, and a seemingly small regional conflict. So there are just so many things that are not even on the radar. And I think there's a need to bring more attention to that. And as I said, a need for more leadership in our broader region and not just the Pacific when it comes to this, and not leaving everything to ASEAN to fix.
Thank you for that, Melanie. Turning to you, John.
So to be very quick, I have a few quick points. First of all, kudos to Australia for one very important step, which is the nomination of Hillary Charlesworth to become the successor to James Crawford on the International Court of Justice. And the sooner the better. And I think that could be very impactful, not least in the Rohingya genocide case. So that just is indicative of the role, the importance women can play. Second of all, let me just add a cautionary remark about the idea of determinations and bureaucratization and kind of trying to technicalize this and shove it off. I'm very, very doubtful about the initiative in the UK to have courts adjudicate and basically take from the executive the state's obligation. I think that could put a lid on certainly preventive action, which would be very difficult to establish through a judicial process and so forth. The state cannot avoid its responsibilities, and really that would be my third point. We must make a better effort, and I would say for civil society, to focus on the state, the major actors in this, the systems. We might want to, in colloquial terms, think about the evil individual, the Hitler, the Stalin, the whatever. That is not how genocides occur. They are systematic, they are substantial, they are foreseeable, by the way, and so forth. And then finally, just to answer the question on the DRC, which kind of makes the point, I don't know the answer to the DRC because I haven't looked at it in analytical terms, but prima facie, there's all the evidence there to support us being deeply worried. And the obligation under the Genocide Convention, which is, again, an erga omnes, it's not only a peremptory norm that should go above all other norms, but is a duty borne on all, everyone, the international community as a whole, individually and collectively. And so we should be seriously looking at it, and our state should be seriously looking at this. And I dare fear that there is actually violations ongoing. Thank you for the opportunity to contribute.
Thank you so much for that, John, and thank you for raising also the effort that exists both in the UK and the US to try to, through legislatures, create a requirement that there are genocide determinations made either by Ministry of Foreign Affairs or, as you said, by the courts. In the instance that you alluded to, one of the big kind of cautionary tales, as we've noted earlier in the discussion, is that it's incredibly hard to make a genocide case, to prove specific intent. And one of the things, thinking again about the young man in the camp in Cox's Bazar, that I'm always struck by is how do we just really manage the expectations, but also remind survivors that even if a court does not reach a genocide finding, that doesn't mean that they did not necessarily experience genocide or horrific crimes, such as crimes against humanity, that we should be equally concerned about. And also, to hit the prosecutorial standard, that means that we're acting too late. It means that we did not respond to the warning signs, to the other crimes that were occurring. So I'm a little concerned it might also leave governments off the hook. So it has kind of a perverse impact from what those who are trying to take forward this kind of well-intentioned effort are trying to advance. It could be counterproductive. So turning then just to you, Adam, for your closing thoughts.
Sure. So yeah, I think those points are all well taken. I think to the question of whether this should be a requirement to conduct genocide assessments should be legislated. There's also often the question of whether the consequences, policy consequences that flow from a government determining that genocide is happening in a particular place should be legislated. I'm also skeptical of that. I think if you want an honest assessment from a government of whether genocide is happening somewhere, you must not attach automatic consequences to it, or you will find out the answer. The question will be, does the government want to have these consequences happen? Not are the factual criteria satisfied? So I'm very skeptical of that kind of effort, and also less, I think, prescriptively or ambitiously, I'm also skeptical of requiring, an across the board sort of human rights report kind of look at all countries at all times, are atrocity crimes happening in a given place. I think it's not practical. I think it does distract from the proper focus on warning and risk. But I mean, it raises the question of if a government, if the US government, from my experience, is going to it's not going to do everything, and it shouldn't do nothing. Like I think the UK approach has been, as a matter of policy, to say that the executive branch will not pronounce on this. It's a matter for the courts. I don't recommend that approach to the US. I think, as we've said, there are reasons for considering this. But I think it's inevitably going to be case by case. In that discretion lies, I think, great risk. But I think it's inevitable. And so I think it's important to consider how the handling of one case informs the perception of the handling of another, especially when you have some of these crises playing out at the same time in parallel to each other. I think it's entirely reasonable for an advocate or an analyst to look at the US government's making a genocide determination in the Xinjiang context, and to ask, and to draw inferences from that about US policy toward Myanmar and the abuse against the Rohingya. These things are not happening in a vacuum. The US will always be able to say things about, well, different tools in different contexts and taking a case-by-case approach, and that's fair to a certain extent. But I think it's reasonable to expect connections to be drawn, and to expect the US to achieve at least a minimal level of consistency, which is why I personally think that the failure to make a genocide statement about the crimes against the Rohingya is deeply problematic and should be corrected. Since it won't be the last administration, it should be this one.
Thanks so much for that, Adam. I think you just summarized how we collectively all feel on the panel in that particular regard, especially also given the amount of resources that were invested by the US government with the support of Canada, the UK, Australia, and others who contributed funding to the documentation effort that was undertaken by the Department of State with outside partners into the case in Myanmar. And also, we don't have the time to go into that in depth now, but for those who are interested, a large component of the interviews focused also on sexual violence, and they really did push to use really strong international standards, make sure that individuals were trained to undertake those types of interviews. And I think in many ways it was cutting edge in its focus with a more gendered perspective on the commission of crimes. So there is a fairly large disconnect between the allocation of resources and then a very muted response afterwards once that was done, and what we've seen in the context of Xinjiang. I think in both, it'd be fair to say our main goal is to see preventive and protective action taken and to see the focus on atrocity prevention integrated into policy. And there's a long way to go in both instances. But I want to thank the panelists for their very thoughtful contributions, very humbling kind of discussion as well on both the genocide determination process and the preventive efforts more broadly. And I would like to thank New Lines and Emily for bringing us all together for this conversation. I apologize that we couldn't get to all the questions. There was a very important and timely question from Wes Rist on also looking at LGBTQ communities and the crimes that are being perpetrated there. Hopefully in future discussions, we'll touch on that. Thank you again. Take care.
Thank you so much, everyone. Thank you to Naomi, Melanie, John, and Adam for such an insightful panel. And thanks to everyone who tuned in yesterday and today for New Lines Gender and Genocide in the 21st Century Conference. I think we've all learned a lot over the past 2 days that without a full gendered understanding of genocide, then we cannot hope to understand or recognize the full scope of the crime. And this means that states, especially those signatories to the Genocide Convention, will continue to fail in their duty to prevent and punish the crime of genocide without this understanding. So I again want to thank all of the panelists who took part in this conference and for our wonderful audience who posed such great questions for our speakers. Please follow New Lines on Twitter at NewLinesINST to keep up to date on our future events like this, and subscribe to our YouTube page to see the recordings of each panel. So thanks everyone for participating. I hope you enjoyed this conference and learned a lot from our incredible lineup of speakers. Have a great rest of your day and stay safe, everyone.